Good morning. My name is Don Vivrette. Pete and Steve will introduce as we go through here. This is Finance and Estate Literacy. It's Your Estate for the spring 2022 session. This is week 2 for advanced healthcare and power of attorney. And that's the process that we're going to go through as we look at these. This is different this year than we have done in the past. We did a workbook that sort of follows through the various 6 weeks, not 8 weeks anymore, explaining what all we're doing. Here's the flow of what's happening, and allow you to use it if you want to write notes and think about questions you might ask or something else, and go through and put those in the book. It's strictly for you. You don't have to turn in your homework. It doesn't change the certificate that you're not going to get at the end of this anyway, but it is for you to be important and learn from it. And a lot of what we're going to talk about in the estate side, it certainly affects this module as well as next week's, which will be wills and trusts, is who do you want to take care of you if needed while you're alive, and frankly, take care of your estate afterwards, and how do you make your wishes known? A lot of these things are driven by tax issues and other things as you go through. So that's kind of important in terms of how we look at these. This is a screenshot of the beginnings of the workbook. The same link is used, as I said before. And if you notice, we go through, last week we went through an overview, people know changes. Today we're going to do advanced healthcare. We're actually going to do it in opposite direction. We're going to do power of attorney, and then we're going to do advanced healthcare. And then next week we'll do will and trust. After that, in week 4, we do retirement. Week 5 is charitable giving. And the last one is estate administration, which is terribly important in terms of all these discussions that we're having and going through this. So what I'm going to do is I'm going to switch my screen.
We can't, your screen is not, you were not sharing what you were talking about.
Thank you. Oh, I wasn't.
No.
I wonder how I stopped doing that. I'm looking at it, it's right there. Anyway, let me click on this and say, here's what I was talking about. I apologize. So the content as we go through, we've gone through the week, we've talked about all of these parts. What I want to do now is to switch to Pete. We're going to go live to the website, which hopefully is now visible. Okay, so this is the website. I'm going to back us up 2 spots since I had been looking at something. So when you first come into the site by itself, that guy out of the way, you come in here. If you click on the workshops, it's always fun seeing how things work when you go live. Click on estates. It's your estate. Thinking. Okay. So the video for last week is already posted. I'm going to scroll down to week 2. Actually, I don't have to scroll. I now have a next button. Next button is the subject for today. Here's the handout material that you can have. It's an outline that Steve had put together, as well as his Ask First form. The workbook is also here, and there are various articles. Did we need to talk about any of the articles, Pete?
No, it's just they're there for them to peruse. It's on the same topics as that we're going to talk about today. So they're kind of pertinent.
They're very good articles and very timely because Pete updates those each time we do these sessions. So each week you simply click on the next button and it will take you to week 3, week 4, week 5, week 6. And as we showed you, the video for last week is already here. And so you can go back and look at what all was talked about last week as we went through, as well as the handout material. So that's where we're going to go. I'm going to stop sharing so we all come back together again. And Pete, why don't you introduce yourself and Steve?
Okay. One of the questions was, are all the handouts available for each session, or do you wait to post them on the session date? Most of the time we post them for the session date, because we want to get the individual outlines for each program from the presenter. So Steve's program outline today is on our website. You could download it. You could also download his Ask First form on there, which I'm going to use to introduce Steve in just a little bit. Financial and estate literacy is a not-for-profit. Our mission is to educate you on money, on estate, and charitable planning. And we try to do it in with the least amount of conflicts. And what I mean by that is that No one is going to receive your contact information, especially the presenters. If you want to do business with any of our presenters, you need to contact them. The control is in your hands. Two is that we do not allow any for-profit business to be a sponsor. So we don't have banks, insurance companies, mutual funds, et cetera, to be a sponsor. The only sponsor that we normally have is charities. And charities normally, in return for their sponsorship, we provide them an opportunity to allow them to come on screen and give you their mission as to what they do.
And just as a note, we were scheduled to have a nonprofit join us at the last minute. They had to cancel. So we would have had somebody today. That was a change from yesterday also. So they will, normally there would have been a charity we would have just talked to. And Pete, I'm going to go away and I will watch the Q&A, and trust me, I will interject along the way.
Okay, great. Thank you, Don. To your left on your screen is Steve Bemis. Steve is an estate planning attorney, and his Ask First form is on our website, but I'm not going to bring it up because I think seeing Steve is a lot nicer than looking at the form. So Steve, tell us a little bit, how long have you been in the practice of estate planning?
Yeah, so I've been an estate planning lawyer for, almost 24 years now. So I can't believe it's been that long, but unfortunately it has been. So
yeah, do you practice in any other areas besides estate planning?
Not really. I mean, there's a few areas that kind of touch on estate planning, like, business planning, forming business entities, some real estate transactional work, but most of it's related to estate planning in some sort, or probate, or post-death trust and estate administration, and also some litigation involving those various areas as well.
Yeah. Let's go right into a basic package for an estate planning attorney is will, what we're going to talk about today, the durable power of attorney for finances, the advanced healthcare directive, and a living trust. Tell us a little bit how long it takes for you to put together a plan for a client, and how much would that cost generally for a client?
Yeah, so typically I would have an initial meeting with the client. Sometimes it's done over the phone or even Zoom these days. And so from the date of the initial meeting, assuming we make most of the decisions relating to that plan, such as who your beneficiaries will be, who your successor trustees or agents will be, it usually takes me, I'd say, 2 to 3 weeks after that to put together drafts to provide to the client. And then once we get those in final form, we'll schedule a meeting to sign everything in my office. I'm a notary, my assistant is, so we can handle all of that process in-house. So I could say start to finish, it can take as short as 2 to 4 weeks. Kind of just depends on the client's pace. Some are more urgent to get it done, and others, I'm almost embarrassed to say, people sometimes take more than a year, start to finish, to kind of just whatever pace kind of the client is on. From a cost perspective, for most estate plans, we can charge a flat fee for what we're doing. For the documents that you described, also would include, preparing deeds to transfer any real estate to the trust. I'd say the range is running, $1,500 to $3,000 from a flat fee perspective. If you're a single person that maybe has one property, you're probably at the lower end of that range. And if you're a married couple and have 5 properties, you're probably at the higher range, just to provide a basic example of where it might fall.
Okay, and does that include changing deeds to property?
Yeah, so usually when I quote a fee, it includes preparing the deeds for at least for your California real estate. We're somewhat limited what we can do if you have real estate out of state. Often we have to get an out of state lawyer to prepare those deeds. The only thing it doesn't include is whatever the county recorder and our recording service charges for actually recording a deed. And that's typically running $100 to $125 a deed these days.
Yeah. We don't talk about preparing deeds too much. Should a client who's never prepared a deed prepare their own deed?
Probably not. I mean, it's not to say that if you looked at one, you'd say I could do it, and maybe you could. I'm not here to discourage people from trying to do things on their own, but there are some considerations involved. There's some property tax, documentary transfer tax exemptions, things that need to be put on deeds that can save you a little bit of money, and in some cases, that. And if you're going to have estate planning, whatever attorney you use, you want to handle the transfer of your properties to your trust at that same time.
Yeah. You don't want to all of a sudden leave that law office and not have that transfer completed.
Yeah. I mean, as you know, Pete, the documents are maybe half the process. And the second part of the process, which actually is equally, if not more important, is actually moving your assets into your trust. And a trust is what we're recommending for, 99% of our clients, these days. So that's a very important part of the process.
Steve, let me stop you for just a minute. There's a question in terms of fee. So just as a guess and realizing every situation is different, probably if someone is single and has a simple situation, it's probably more like $1,500. If it's a fairly simple couple, we don't have multiple marriages in the past, we don't have 6 properties around the country, that might be as little as $3,000.
No, that might be closer to 2,000, just to give a range if it's a simple, one property. So we're doing maybe one deed for your house, as an example. As we start having clients with multiple properties, or maybe they have some businesses or LLC or partnership interests, things like that we just kind of have to deal with outside of those documents as far as transferring them to your trust, then I'd say it starts getting a little bit more expensive than that 2,000. But I'd say most of my clients are they have estates, 5 million or less is kind of a typical client, maybe has 1 or 2 properties. And I'd say, the average fee for those is running kind of in the $2,000 range, just to give an example.
When you
if I have an existing will or trust that's from the past, are you going to review it, or do you just make minor notes on it that now it's good for California?
I mean, I'm happy to review your existing estate plan, and I'll give an honest answer. I'm not an automatic. I'm not going to rubber stamp somebody else's document. I'm going to recommend that you do an amendment or restatement. I'm happy and do it all the time. And typically for reviewing an estate plan, if I don't end up preparing new documents, I'll do that on an hourly basis, and my hourly rate is $400 an hour. So, and I know what I'm looking for in these documents. So, I mean, it's something that, may take an hour or two to review them and then talk to you about them, or send you a letter or an email kind of describing what I found.
Yeah, when an attorney reviews another attorney's work product and they make a change in it, they become liable or responsible for the entire estate planning package. So a lot of times an attorney, instead of, if it's a massive trust that may not be needed, they may do what's called a restatement. Steve, what is a restatement?
So it's an amendment to your trust that deletes your prior version of your trust and replaces it with a new trust document. And technically it's an amendment. And the reason we do that is because we want to keep the same name and date of your original trust, so that any assets that are already titled in your trust, we don't have to retitle them in a new trust. So it's really the same trust entity, but a completely new trust document that's called an amendment or restatement, or amendment and restatement. So yeah, it's a good way to get you a new trust document, which makes sense in many cases. If you've had 3 little mini amendments, from your original document, often it's kind of handy to wrap all those amendments into one document for your successor trustees, or whenever the time comes where you need to present those documents to a bank or financial institution.
Yeah. In our first session last week, we talked about the importance of title. And in the workbook, that Don has put together, it's just a great idea to list all of your assets, put a title next to each asset, put the cost basis, what you paid for it, or if you have an apartment building, less depreciation, what is the cost basis of that asset, and what is the market value? And once that, an attorney would really appreciate it if you came into him or her and have that information, because title determines what document that you will need in the event of an incapacity. And that leads us into our discussion today, which I think are the two most important documents in an estate plan. And that is the durable power of attorney for assets and the advanced healthcare directive. Because if you don't have either one and you become incapacitated, you'll end up in a conservatorship. So we're going to do it a little different this time than we have in the past. What I'm going to ask Steve to do is that to share his outline, and then we're going to, you had an opportunity to print off his outline, which is just 2 pages. And then we're going to come back on screen and we're going to talk about each issue. So why don't we put your outline on the share on the screen for a second, Steve? So here's,
yep.
Yeah, I could see it. And if you scroll up a little bit, yes, there's Stephen's address, his office number, email address. And so if you want to touch base with him, please do. So our first topic for today is going to be the power of attorney for finances. And we'll come back on the screen with the outline in just a little bit. So do away with the, which you already done.
One step ahead of you, Pete, I guess.
Yeah,
or maybe too fast.
Always, always. So what is a power of attorney for finances?
Yeah, so that's a document that conveys legal authority to someone else to be able to make financial decisions or execute financial transactions on your behalf, you know, whether it's, go ahead.
So how does property have to be titled in order for your, if you give somebody a power of attorney, what do you call that person?
So there's kind of 2 terms that are used. The legal term is attorney in fact, but you also see it referenced in many documents and also works perfectly well, or your agent. So attorney in fact and agent are used kind of interchangeably for the person you appoint in your power of attorney to be able to make financial decisions on your behalf.
And so how does that, let's say I have a bank account and I'm needing a power of attorney. I need my power of attorney agent to access that account. Can they, if it's in a joint tenancy, if it's in a living trust, it's or does it have to be in that person's individual name?
So generally speaking, with the financial power of attorney, it really is only going to give your agent the power to handle assets that are in your individual name. You mentioned joint tenancy. You know, you might, you know, I've seen it go both ways. Okay, but it's really transactions that you could execute as an individual. So assets that are, for example, in your trust, the power of attorney does not govern or give the authority to your agent over assets in your trust. That would be governed by the successor trustee provisions in your trust document.
So why do we need a power of attorney? If I have all my assets in trust, why do I need a power of attorney?
So let's use your example and assume that you have every single asset in your trust. And frankly, that's unrealistic. It almost is never the case. But even if you assume that, there are still transactions that are not necessarily asset-based where you might need someone to handle on your behalf. So for example, someone had to sign a tax return, or if someone had to talk to somebody on the phone on your behalf to get financial information or to deal with, let's say, Social Security on your behalf, a power of attorney would be necessary. Yeah.
Insurance bills,
Yes.
IRAs, 401ks, all of those things, they don't just talk to you unless you can show them that you have the legal authority. If you say I'm the spouse, that doesn't work.
Yeah, that's one of the biggest misconceptions is I'm the spouse, I'm the child. They'll talk to me when I go to the bank, and they'll tell me how much is in my husband's account. And you're going to be, unfortunately, you're going to be surprised that they will not talk to you. Even with the most basic information, they might not even tell you whether he has an account there, let alone the details of that account, such as, what's the balance or what securities are owned by that account.
Yeah, and we're here in Orange County. It's the banks, hospitals, everybody wants to know, if you're not the individual, what is your legal authority to talk or to speak on behalf of the other individual? How do you compare it to a trust or a will?
Yeah, so a will, I'll start with that. I mean, a will is a document that governs distribution of your estate and only becomes effective at death. It's kind of the opposite of a power of attorney, which is only good during your lifetime. So, a power of attorney, or the authority that you grant someone to act on your behalf with your financial affairs, that terminates upon your death. And then you kind of have a trust, which is kind of a hybrid between a will and a power of attorney, meaning the trust does what a will does. It says what happens to your assets at death, but a trust also grants your successor trustees authority to act on your behalf in the event of incapacity during your lifetime. But like, as you said, Pete, I mean, almost every client I have, the goal is to put most of their assets in their trust, so the successor trustee, but there's always going to be assets that are not. It could be, like you said, IRAs, 401ks, life insurance, things like that, where we need a power of attorney. It could be just some smaller assets, your car, and if something needed to be done with that, where a power of attorney becomes necessary in order to avoid a conservatorship.
We just had an individual who was in the hospital, had a major stroke, and he's right-handed, and he wanted to make a change. We had talked about making a change in his trust so that it's a second marriage, and that both sides had 2 daughters, and they wanted to make sure that everything gets split equally amongst the 4 daughters. Well, before he had a chance to amend his trust, he had a major stroke and a heart attack. And so we went to see him in the hospital with the legal counsel, and who drafted the amendment. And his stroke could not move his right hand and sign. So luckily, he had put together a power of attorney, durable power of attorney, which gave the attorney, in fact, the power to sign on his behalf. So it's that durable power of attorney. It's almost like it's a really important document. You never know exactly when it can come into use. And what does durable mean versus just a regular?
Pete, let me interrupt for a minute and ask a couple of questions that have come in.
Sure.
If basically all of my accounts are, joint with my spouse, do I really need a power of attorney? Can she just do everything?
Yeah. So when you have a joint account, all of the joint account holders do have access to that account. So if something happened to her or her incapacity, her husband could still sign on that account. I would still recommend a power of attorney, because we can designate successor agents, and what happens, after, if her husband passed away, things like that. So
plus if one of you has a 401k or an IRA or something else, that's not joint. That's individual.
Or Cox Cable. or Verizon, or an insurance bill, hospital. I mean,
it can be lots of little things that pop up, and you may find that Cox will talk to you, but then you call the phone company and they won't. Okay,
they want that power of attorney.
There will always be something little where a power of attorney, you'll be very happy that you have it.
I'm going to give you a stupid example, and I accept that it's stupid given what you were just talking about. Can I have a power of attorney?
You could come on screen if you'd like.
Oh, heaven forbid I do that again. We won't go what I found for him the other day. Given Cox and Verizon, can I have a power of attorney that says you can talk to Cox but not to Verizon?
You can, yes, you can.
But
you can have powers of attorneys that are, it's limited to a specific transaction.
So for instance, if I'm selling my house, but I'm going to be out of town, I might have a power of attorney to an individual to handle that transaction only.
Correct.
Okay.
Yeah.
Okay.
We've said in the past that a lot of times banks don't like powers of attorney. Do you recommend that they take your power of attorney in and say, all right, let's figure out what form you need and let's deal with this?
Yeah, it's a good idea. And I've learned that a lot from working with Pete over the years. And I've found it in my own practice too, where banks just don't like powers of attorney. I think they see lots of fraud with powers of attorney because they're easy to get online, forms and so forth. So they're very skeptical of powers of attorney. Now, the law is very clear that they have to accept it. But
you might run out of money trying to fight for that.
I don't know that they're going to. They're not going to fight you on it, but you may.
No. I mean, you can't access the checking account while that's occurring. So
yeah, but you may have to go to court to get a court order affirming the power of attorney, which does have a cost. But.
Yeah, I just want to introduce Trevor. Trevor Murphy is a professional fiduciary and is also the president of Financial and Estate Literacy. And he will be our Don next week. Trevor, you're more than welcome to show your face if you want, if you're decent. Otherwise, stay hidden. And because this is I think the conversation with the four of us, I think clarifies for the audience of how important this document is, and also when we get into the advanced healthcare directive.
And incidentally, when we do these in person, this is what we do. We stand around and banter. Incidentally, a very important point, especially for Steve in this case, is one of the questions is, I live in North Carolina. And the answer to this is, you're speaking California. They may all be similar in other places, but you can only do this for someone in California. Is that correct?
Correct. Yeah, I can only prepare a form under California law that's going to be executed in California. If you were visiting and you wanted to execute a form, but for most people who live out of state, I'd recommend that they hire a local estate planning lawyer to prepare these and other types of forms. Yeah. It's absolutely true, though, a California form under the United States Constitution is perfectly valid in North Carolina. But again, if you show up with a California power of attorney for a North Carolina bank, they might even be more skeptical than we see, here.
So what does the term durable mean?
So durable just means that your power of attorney survives you becoming incapacitated. And so these days, you almost never see a non-durable power of attorney, meaning a power of attorney that you appoint an attorney in fact or agent that expires once you become incapacitated. For most people, the power of attorney, that's the whole purpose of it, is when you do become incapacitated, to have someone who can act on your behalf. So
this is another thing that I find with institutions, banks, brokerage, is that if your power of attorney is Bank of America, I'll use as an example, they look very suspicious on any power of attorney that is not theirs and is over a year old. And so you may want to check with your institution as to what they require. Now, by the way, can you fight Bank of America and say, demand that your durable power of attorney be used, Steve?
You can, yeah. I like I said, California law is actually, there's a there's a statute right on point that says they have to accept a valid power of attorney, and they actually don't have any liability for accepting your power of attorney. But what they find out is, regardless of what that says, they get sued when there's an issue. They're the deep pockets in these family disputes if someone uses an improper power of attorney. So they're very suspicious. So like you said, and maybe Don mentioned as well, a lot of the larger financial institutions have their own forms for powers of attorney. And so it's not a bad idea to ask if they have their own form. One of the things that I've noticed that creates some issues is you do want to, an attorney drafted, or we'll talk about a little bit, there's other forms you can get for power of attorney. And if you do one for the financial institution, you want to make sure they're consistent. Meaning either they're appointing the same person, you want to make sure that one doesn't invalidate the other. And so that can be really, really challenging, actually, I found, even though as a practical matter, using the form that the financial institution has is probably the best way to go for ease of use.
Okay. And now durable means versus regular power of attorney, it's through incapacity. Is that correct?
Yes, it's still valid even after you become incapacitated.
So some powers of attorneys have that, don't use the word durable in it. They just say this is effective through incapacity.
Correct. Yeah. I mean, it really, the form doesn't necessarily need to say durable, as long as it has language that makes it clear that it survives your incapacity.
And that's the important part.
Yes.
Okay. So
can I add something, Pete?
Sure.
I came across this the other day. A lot of the ones that don't last through your incapacity.
Trevor, can you come on screen, or is that not feasible? There you go.
I came across a form that says general power of attorney, and there was explicit language in there that said that it does not remain if the principal becomes incapacitated.
Yeah.
So you have to read your powers of attorney
Just to make sure.
Yeah. Now it can say general and still have the language for the durable, for the incapacity, or not. So there's no like one title on every single form that's exactly the same. So you got to figure out what they are.
Yeah. And it's really important to read. So the next part about reading your durable power of attorney is it going to be general? Is it going to be limited? Is it going to be immediate? Or is it going to be springing? So let's go through what all those terms mean. First of all, what does it mean when it says a general power of attorney?
To me, that doesn't have a real meaning within a legal connotation. It probably references it's for all financial transactions, or at least for numerous financial transactions that might be described in the powers section of your power of attorney. So it's intended to be more all-encompassing. Basically whatever transaction I could do at the bank, I want my agent or attorney in fact to be able to do.
And limited means?
It's usually for a specific transaction. It could even be for a specific time period that I only want this person to have. I'm going on a 6-month cruise, and I want this person to be able to have power while I'm gone. We could even limit it by duration or date. But most limited powers of attorney you see have to do with, I'm not going to be available and I want someone to be able to sign all of the documents relating to the sale of my house, for example, and can grant a power of attorney in that context.
And then what does an immediate mean versus a springing?
Yeah, so an immediate power of attorney grants your agent the power to act immediately, even if you still have capacity. So it doesn't take away your power to act, but it just adds an additional person, your agent on the power of attorney, to be able to act. And so the immediates, you don't have to prove that someone's incapacitated before the powers in the power of attorney become effective. Whereas, just to touch on the other side of that, a springing power of attorney. And the reason for that descriptive term is it doesn't spring into effect until you become incapacitated. So you'd have to, most power of attorneys would say you need 1 or 2 doctors' opinions of incapacity before you have the ability to exercise the powers in the power of attorney.
Yeah, I'm getting to the point where individuals over 70, 75 should definitely have an immediate power of attorney versus a springing. But what are your thoughts on that?
Yeah, I think our thoughts are pretty aligned, Pete, that especially for married couples who are in stable long-term marriages, anyone who's getting older, the immediate powers of attorney just work so much easier because your agent doesn't have to take you to a doctor or sometimes two to get that opinion. And sometimes those are hard to get. Sometimes the person who might be incapacitated at that point does not want to cooperate with getting those doctor's opinions. And so it can be very challenging in certain situations to, you're sitting on this springing power of attorney, but you can't get the opinions you need so that when you take it to the bank, they'll accept your authority.
Yeah. And the thing of it is that to get a medical doctor today to sign off that someone has lacking capacity, it doesn't happen in a day. It can, and if you have 2 medical doctors that need to sign off on that, that makes it even more difficult. And usually when you need these documents, you need them right now because you need to get into the bank account to pay a bill or to make a change. And it doesn't happen because you can't get a medical doctor to sign off to say that you're lacking capacity. So
yeah, kind of in my practice, I mean, I'd say 95% of the powers of attorney I do are immediate for clients. I'd say the situations where we go with the springing is where it's often maybe a younger person who doesn't have, I'll say, a trusted person that they have a ton of confidence in, or there's not the obvious person, a family member or a close friend that they would trust implicitly. So we put in a springing, so we still have that in place if we needed it.
yeah.
But if you've got a trusted family member or friend that you trust enough to designate, I'd say in most cases, we should trust them enough to make it an immediate power of attorney.
Yeah, and that, we come to the word trust. People believe that the problem is outside their family. And sometimes that's true, but most times it's in the family where the financial abuse takes place. And so one of the things that banks and institutions such as insurance companies or brokerage houses have trouble with is family members and family members who abuse this document. So be critical of your own family in a sense that don't pick the son who just got out of bankruptcy maybe, or don't pick the individual who just is an alcoholic or is bipolar, or there's numerous reasons why you may not want to pick one family member over another. I see people giving this document sometimes to give the power to a friend. And when the friend is put in the situation of making a critical financial decision, it is an enormous burden on them. So any thoughts as to, is this an issue when people sit in front of you and you ask them, who do you want to name first? Who do you want to name second? And do you ever do, hey, let's have my 2 daughters be co? What is your thoughts regarding that?
Yeah, I agree. Designating a friend as an agent is it's not that they wouldn't step up to the plate, maybe be a good neutral party, but you also got to consider, are there going to be different family members, children tugging on his or her shirt sleeves saying, do this, do that. And it could put that friend in a very difficult spot. But, you know, there are times where we do, I'd say in most cases, especially with older clients, we're designating kids of some sort. So to address your next question, is it a good idea to have co-agents, meaning two people as agents? And, you know, I'm probably more sensitive than most attorneys to the feeling of parents not wanting to hurt anybody's feelings.
Yes.
And to maintain harmony amongst their kids. So, you know, I'm not as opposed to co-agents as I think most attorneys, or maybe even you would, Pete. But it can be ripe with problems, and what if they don't agree? Okay, and we can set up powers of attorney so that either one of them can act alone. But even just having that language in there, so you know, if Jennifer goes down to the bank and pays a bill, and you know, your son Bobby doesn't like what she did, even though she had the power to do it, I mean, it can create some issues. I'd say in most cases, if there is one person who makes the most sense, that is the best way to go. And then we can just build in successor agents if that person is unable to act.
Yeah.
Let me play off of that a little bit. First of all, if I have an immediate power of attorney, so it's in effect right now.
Don, you could come online.
Okay.
We'd like to see your face.
I'm like Trevor. What? No, you don't want to see me. If I have an immediate power of attorney in place and I change my mind, can I easily remove that person? Now, admittedly, there may be different institutions that have that, but I have the right to rescind it as long as I am in capacity, that I have capacity to do it.
Yeah,
Yes?
that's correct. Yeah, you can always change it. You can either revoke it, you can do a new power of attorney that revokes the old one, or just a simple revocation that revokes a power of attorney that you have in place. So it can always be changed at a later date.
And when I die, it dies with me, because then it's your executor who takes over on the estate.
Correct. Yeah, your agent, the minute you pass away, the agent's authority terminates.
Okay. And if I don't trust my kids, I don't have any friends that I trust, I don't like anybody, and no one likes me, can I appoint Pete or a professional fiduciary? Not necessarily Pete. I understand. Maybe Trevor, but he won't turn on his camera. So I could also use a professional fiduciary.
Yeah.
Yes, you can. And I've worked with both Pete and Trevor. And
by the way, he likes me. Steve likes me much better.
They're both excellent. But the challenge with whether it's Pete, whether it's Trevor, or someone else who's a professional, is just having the clients get comfortable with them.
Yes.
You know, I mean, my recommendation of professionals only goes so far. I mean, this is some person who could be paying your bills if you needed help, if you became incapacitated. And I think most, whether it's professionals or other, even if we have an immediate power of attorney, they kind of sit in the background until you have a need or need help with your managing your finances.
This is not the document that you give out randomly.
Right.
You keep it close to your vest. It's probably the second most abused document there is out of the estate plan. And so you got to be careful. It's a very, very powerful document. And that's, speaking of power, what are powers? When we talk powers, what do we mean?
Yeah, so the powers could be anything, but I mean, it could be the power to write checks, withdraw funds from accounts.
You're giving the authority to the other individual. Is that what you mean by power?
Correct. Yeah. So your power of attorney is granting, and I'm just using agent because it's easier to say than attorney. In fact, granting your agent the power to, you know, write checks, withdraw funds, make deposits, sell stocks and bonds, sell real estate, sell your automobiles, all of those things. Now, your agent under the power of attorney has a fiduciary duty under the law to exercise those powers on, you know, in your best interest, on your behalf. But it can be far-reaching, and so that's why you said, Pete, there at least the opportunity for
Abuse.
You know, abuse is definitely there with powers of attorney.
one of the things that most people forget is the power to make gifts. I've had a situation where all of a sudden a mom has had a stroke, and Christmas time is coming around, and the kids all call me and say, hey, mom was giving us $10,000 a year at Christmas. Can you do that? And I go, give me something in writing where it says that I, as the agent for your mother, where it gives me the power to make that gift. And if it's not written, can I do it just because the kids say so?
No, you really can't. I mean, I think you would be exposing yourself to liability for making gifts that are not explicitly authorized by the power of attorney. And there's a few what I'll call kind of special powers that you really need to pay attention to that can come in either very handy, either you want them or you want to make sure maybe you don't want them in your power of attorney. And you raise a great one, which is the power to make gifts, whether it's to children, power to make charitable giving as well can be if there's an organization that relies upon your giving and you become incapacitated, if your power of attorney doesn't authorize that agent to continue to make those types of gifts, he or she may not be willing to do that and to take that liability risk associated with it. The other one, and you touched, the only reason I bring this one up, Pete, you touched on it with the situation you had with a client who'd had a stroke and a heart attack and never executed his trust amendment prior to that event. Is the power to amend your trust, is that a power you want to have included in your power of attorney? Because if it does not include, number one, the power to amend your trust, and number two, the explicit power to be able to change beneficiaries. There's statutes directly on that. If your power of attorney does not provide that power explicitly, then they can't. But in some cases, maybe you want your agent to be able to amend your trust to maybe change the trustees, but not necessarily change the beneficiaries, for example.
It is a powerful, powerful document. It's just people underestimate the power that document can create. Like you said, it could change beneficiaries. You could change amounts, making gifts. You can have an enormous power given over to the agent, and therefore you need to be very careful of this document and how you do it.
And generally, I don't include those expansive powers unless I see a reason why it may come in handy or may be necessary, or maybe there's already some health issues where it could come into play.
One of the things is that I usually always recommend for people not to use a pre-printed form. Don't go to the drugstore to get one of these. I usually don't recommend people going even to the probate code and getting one because of the power of this document. If somebody comes to you and says, hey, I don't want a living trust, would you say essentially, please use a durable power of attorney at least?
Yeah, I mean, I've kind of come around to, and I even have these conversations with clients who come in to do estate planning about their adult children. I mean, really, everyone who's 18 years old or older, once they become an adult, should have a power of attorney and a healthcare directive in the event of incapacity. And it can be a very simple one. It can be a springing, if they don't know who their agent might, don't have a perfect person for that. But it's just one of those things that everybody at a minimum should have these documents. And even in my own case, when my wife and I, before we got married and we're together, I said, hey, we should each have a power of attorney and a healthcare directive at a bare minimum, just to cover us in one of these events.
No, okay, let's go through this scenario. I'm single. I don't have any of these documents. I end up in the hospital and somebody needs to get into my bank account. So what happens if I don't have any of these documents? We need money. What would my brothers and sisters do?
Yeah, so they would have to go hire a lawyer who would petition the probate court to be appointed as your conservator. And, you know, in the case of if it was for finances, it would be conservatorship of the estate. And that's a time-consuming, expensive process. And that conservatorship lasts and has yearly costs and court petitions as long as that person remains alive and incapacitated.
Yeah.
So
So if conservator needs to be named, can you name that conservator or that person in your document if it comes to that?
yeah, I mean, typically we do that in your power of attorney. One of the things it can also do is nominate who you would want to be your conservator if it becomes necessary. It's a little bit counterintuitive. The document that should prevent you from needing a conservatorship is where you can nominate. The law creates a priority of persons, spouse, children, parents, basically an order of closest family members has priority to be appointed.
Yeah. Okay. So let's go to the other document that I think has nothing to do with money, and that is the Advanced Healthcare Directive. Describe a little bit what it's about, a little bit of the history, and kind of why is it important?
Yeah, so issues relating to personal care and healthcare decisions aren't typically addressed in your financial power of attorney. Historically in California, it's a little bit even before my time, we used to do what's called a power of attorney for healthcare. And then at least in California, we had a document called a directive to physicians.
So, it's still, I was at the hospital yesterday and they still call it a power of attorney for health.
Yeah, and a lot of these terminologies, I think, get interchanged. So we used to have two, I think when I first became a lawyer, two separate documents to cover what the state of California now calls an advanced healthcare directive. And it kind of does two things. Number one, it appoints an agent for you to make healthcare decisions, care decisions on your behalf if you can't make them for yourself. And then it has some optional provisions regarding end of life and what kind of treatment would you like to be kept on life support under what scenario or circumstances if that scenario occurs. So kind of addresses both of those scenarios, and then has a couple other optional provisions that aren't as ultimately as important for what we're talking about.
Yeah, it's in our family, we did not have this document. And I have three sisters, and my dad was in the hospital intubated. And my sisters and myself, we had a disagreement as to whether or not to keep him intubated or to remove it and allow him to die. And not having the document and not having the conversation put an immense amount of strain on our relationships. It was immensely difficult for my father. So it literally started the workshop series because I had to let other people know how important this document is. If you don't have a discussion as to who's going to make decisions for you based on what you want, and then it's up to the doctors, and it might even be up to the courts if it gets to that. So
as a note, incidentally, in Pete's example that he just gave, here's the counter for mine. My father winds up falling, cracks his skull, all kinds of stuff. I go to the emergency room, look across, and I see my father intubated. I held up his durable power of attorney to the physician and said, why is he intubated? If not, he's dead. And I said, with this document, do I have the power to remove it? And he said, yes, and he'll be dead. And I said, leave him on it until my sisters got there all the other. But there was no question, no dispute, no nothing, because I just held up the document. This was before everything was electronic, and said, I had that choice. So just as a note, it does work wonderfully in most cases.
And that the purpose is so that to appoint an agent and also to whether or not somebody wants extraordinary means to keep you alive, which extraordinary, we can have a 5-hour discussion as to what that means. We're not going to do that today, but appointing an agent, again, should we name one individual? Should we name 5 individuals? Should we do who should we name in our family?
Yeah, so usually it's, I'd say with most clients, it's spouses, or if there's no spouse, it's adult children. Sometimes it's friends like we talked about, but again, I think that puts them in a very difficult position. I think for the same reasons with the financial power of attorney, it works best if there's one person appointed. And again, we can put alternate agents there. Again, there are many clients, they want to have multiple or agents, like 2 kids appointed, and we can do that. And we can include language that says that either one of them can act alone. But you also got to keep in mind, if you're dealing with the doctor or the hospital and they see this form and they see there's 2 agents, even if I have language in there that says either one of them can make a decision, they may still want to hear from both, just because they're concerned about their own liability. And maybe not unreasonably so, because they are making a very difficult decision that may end someone's life sooner than if they didn't carry out that order, like what Don was talking about.
Yeah, the good news is that most of us will die in our sleep. So hopefully the advanced healthcare directive doesn't become important, but there are in cases where where you have multiple kind of injuries, and where sometimes the cure is worse, the quality. I guess what I'm trying to say is quality of life is really important. And that's kind of the discussion that you need to have, whomever you pick as the agent. And the agent can't be a wallflower. You need to be, the agent needs to be able to communicate with the medical industry. And
you want an advocate, someone who will
you need
advocate
an
on your
advocate.
behalf. Yeah.
It's doctors at hospitals are hospitalists. There's board and cares. There are assisted living facilities. There are, it's massive, and they're all busy. And so you need an advocate who has the time, who has some skills, who understands you as far as what you want, as far as medical decisions to be made. One of our charitable sponsors is going to be the Hemlock Society today. They couldn't be here, but some people believe that they want to have the power to take their own lives when they want. And that is legal here in California if you go through certain steps, although it's not very easy. And all of us are going to die. Dang. So we got that thing in common. And so, but it's very rarely talked about. And so you need to discuss it with your family members. I always recommend Thanksgiving. The turkey is dead, so will we. So let's have a little discussion before we start eating. And
I think, Pete, your comment, it recognizes the limitations of this form, especially if you use the strict statutory version of it. There's so many scenarios that are not covered by it, and that's where it's helpful to have that conversation with whoever your agent is, to describe to them in more detail maybe what you would like to have happen if you're in a situation where your end of life decisions, so to speak, come into play.
Yeah.
And to that point, a question has come up in terms of, if I have an advanced healthcare directive, does that include coverage for mental health as well as physical health? Or does that have to be separated, designated separately?
No, it covers all of your healthcare, mental, physical, or otherwise. That agent would have authority to make decisions on that behalf if you can't make them for yourself. Yes.
Yeah. Dementia is just huge, memory issues, Alzheimer's. It's just, what does an agent do?
I'm sorry, Trevor, that was really weird. As I turned off my camera, you turned yours on. I'm going, wait, I just changed to Trevor. Oh my gosh. Sorry.
So using that, the advanced healthcare directive for somebody who has dementia or Alzheimer's, and having to place them into an assisted care or an aborted care, these things are just major issues.
One thing I wanted to bring up is, and Steve, you can probably speak more to this, but a lot of people don't understand that this is the document that determines or gives someone the legal authority to place you somewhere. So out of your home, or stay in your home, or in an assisted living, or anywhere, your agent for your advanced healthcare directive has the legal authority, not your agent for power of attorney for finances, not your successor trustee, but often they may be different people because of the different jobs. And so if you're, for example, your successor trustee and your agent for your healthcare directive are at odds or don't get along, that is a possibility where, because you have one paying for the care and then you have one directing the care, and they need to be on the same page.
Yeah, and I've seen lots of what I would generally characterize as a financial power of attorneys that go into a lot of the healthcare and placement, have powers included in them, which is okay. You just need to make sure it doesn't conflict with what your healthcare directive says, or if you have different people that have apparently been given the same power in different documents, who ultimately gets to exercise that power. And Trevor brings it up because we had that scenario with a client recently deciding, because she decided ultimately her kids do not get along at all. And so she said, well, maybe a professional fiduciary. But when it came to the healthcare directive, she was hesitant to go with a professional, less so than on the financial side. And we had the same discussion that Trevor brought up, which is, okay, if her kids want her to be, or don't want to put her in a facility because they don't want to pay for it, for example, you could have a little bit of a conflict between what I'll call the money person and the person making the care decisions, which can cause some problems.
Yeah, in serving as a professional for somebody for their advanced healthcare directive, we spend probably 2-3 hours with the individual talking about, what are their medications, what are their desires and goals, how do they feel about hospice, how do they feel about taking extraordinary means to keep them alive, how do they feel about stomach plugs, how do they feel about being intubated, how do you feel about having dementia, how do you feel if you have dementia and now you get pneumonia, what do you want us to do? It's not easy, and even to discuss. My own mother, she said to me, if you bring it up one more time about dying, I'm going to eliminate you from my trust. So I might be overemphasizing some of this, but you need to have that kind of conversation. And you cannot appoint an agent who's out of the area. You can't do this by iPad. You can't do this just by phone. It takes time and you need to be local. You be very careful of religious beliefs, for both the agent and the individual that you're caring for. Medical knowledge, if you lack medical knowledge, there are a whole new group of professionals. Most of them are retired registered nurses who are just wonderful resources that can help the family and can help us as professionals make medical decisions. So there's help out there, but you need an advocate. No way around it. Let's see, family member, organ donations, burial instructions, are these items that should be in your advanced healthcare directive?
Yeah, no, the statutory form has places for both. In theory, we could put them elsewhere, but this is a great place to put them. We know that they'll be legally binding upon whoever has to execute those instructions. So yeah, it's a great form for that.
So don't make sure that if you appoint somebody different than your advanced health, than your power of attorney, and you appoint somebody different, make sure they communicate well, right?
Absolutely. And just to touch back on the burial instructions, one, generally these two forms we're talking about today are only good during your lifetime and terminate at death, but the agent you do appoint on your advanced healthcare directive does have control over your remains after you pass away. So again, another thing to be cognizant of, if that's somebody different than, let's say, your successor trustee on your trust, who's going to be paying for the funeral, to make sure that those two people, if they're going to be different, can work together.
Yeah. You can have a funeral that's under 1,000, and I just got through paying for a funeral that was close to 30,000. So there's a huge range of funeral arrangements.
Yeah.
Let's see. We talked about end of life decisions, appointing an agent. We talked about organ donations. Does that need to be in your advanced healthcare directive?
That's where I put it. I know that you can do it through your driver's license as well. It's a wish that you want to make known to whoever's going to be in charge of those decisions. The form has a great place for you to put some instructions in that regard. I mean, just to use my father as an example, when he passed, he didn't check the organ donation box, but my mom was the agent, and we were able to make decisions just as being the agent. And so we were able to they were able to use what they could. So,
yeah. Well, knowing your dad, I think he would have been happy with that. By the way, how did it feel growing up with a father who was also an estate planning attorney? You got a little legacy there.
Yeah, I know. I don't know where to take that. I was lucky to be able to work with him for 20 years. And as I like to describe, I got all the benefits of working for your father without some of the negatives that you can hear about with working with families. So yeah. I was very lucky and fortunate. So
yeah, he was a great guy. Talk a little bit about forms. There's attorney drafted forms. There's medical association. Is this one that you absolutely need to have completed by an attorney?
I don't know. I would say no. I mean, the basic form I even use in my practice is pretty much the statutory form. I do have some different versions of the end of life decisions. And based on my conversations with the clients, sometimes I'll propose one or the other, because the statutory form is, as you know, Pete, it's got basically like one sentence that covers this scenario. I've got a version that's like a page. I've got one that's like a paragraph, and I can't even take credit for creating these. Every once in a while we come across them and we see one that we think does a nice job of describing what maybe most clients might like. But I think the statutory form would generally work okay. I mean, you may disagree, Pete.
No, I think the
Yeah.
statutory form is fine. California Medical Association, I like their form. And when you're in a hospital setting, they're familiar with it because it was put together by the Medical Association. The form is not the issue. It's the conversation that you have with the agent. Does the agent really understand what you want, or do you understand what you want yourself? Because I evolve as I go and continue and get more experience. I want less and less. Give me morphine is probably the only extraordinary thing that I want today based on my experience with what I've seen. But I give my right to change my mind as well. And because you never know until you actually get to that particular point, because you can't talk to anyone after you die and say, hey, do it this way.
I mean, what I see a lot, Pete, and maybe it's okay, is someone who says, yeah, I don't want to be kept alive artificially.
Yeah.
My agent can do whatever they want. I mean, I get a lot of that. And that might be okay, as long as your agent feels empowered to then go make those decisions. You just don't want a situation where your agent's like, I don't know what he wants. I know we checked this box, but maybe we're in a gray area that doesn't fit the language checked perfectly.
Well, we have here in California, by the way, California courts will never pull the plug on anyone. In other words, there's a vent farm they call them a vent farm in San Diego. People who are intubated, and they've been intubated for over 10 years. And some of them have a healthcare directive with an agent, but the agent believes that after 10 years, there's still a possibility that you could come out being normal. I don't know if any medical fact or research that shows that, but there's a lot of people who have that belief. So picking out your agent and getting them to communicate to you what they believe in is really, really important. You don't want an agent to come in storming into the hospital and saying, this is what I demand. You want somebody who is somewhat of a diplomat and who can communicate because with the rest of the family as well. Just because you're appointed, many other individuals in the family may have something to say about what happens with mom or dad. And there's an immense amount of emotions. And in my family, my mother was the worst person that my dad could have picked. She didn't like hospitals. Blood scared her. And so she never went to the hospital. So, look at each individual situation. It is, again, it's your life. We were going to name the program "It's Your Death," and somebody talked me out of it, said nobody will come to that particular program. So
that would be a tough sell. Yeah.
Yeah. So forms. So the Council on Aging has forms. Every hospital will have a form. They want you to complete one before you are admitted. They'll ask you for one. They don't want to make those decisions. They want to have an agent make those decisions if regard life or death or another procedure. The probate code is a form that they can use. An attorney drafted form is what you can use. But the important thing is giving somebody else the legal authority to make decisions for you if you can't make it yourself. And those decisions need to be made based on your wishes. Other advanced healthcare directive issues that you talked a little bit about, post. You want to go through a little bit of that?
Yeah, I mean, I'm not that involved with pulse forms necessarily, but I do see clients that have them. But that's something you do with your doctor. I think they can also be used with a nurse practitioner or physician's
What does
assistant.
PULSE stand for?
Let's see, I have it
Physician
written down
orders
here, yeah.
for life-sustaining treatment. In other words, your doctor has said, if all else fails, this is the order I have for my patient. And the reason, and Pete and I have had this conversation, my sister, who's a bit older than me, I am the lead person on her advanced healthcare director and all those things. She has a pulse, which is frequently pink. They put it on the refrigerator door. And if a paramedic comes to your house, they're going to look for your kitchen, not for food, but to see if there's a pulse. Now, this is in Santa Barbara. I don't know about down here, because it is an order by a physician to take certain actions. In her case, DNR. She does not want to be resuscitated. She does not want these things. And a pulse is signed by the physician, which is why Steve is going, I don't do these, because despite all of his skills, he's not a physician.
Yeah. So yeah, it provides a little more detail regarding certain procedures if you're in a situation like DNR, like Don said. But this is something, it's an order signed by a doctor that's kind of in your, medical file, so to speak, whether that be on your refrigerator or otherwise. But again, if you're going to fill out a pulse form, you want it to be consistent with your healthcare directive. Just make sure that none of the orders that you're wanting and having your physician make on the pulse form counteract what you have in your healthcare directive. So.
Yeah, and the reason why it's pink is that so it stands out in medical files. By the way, doctors, nurses rarely read the files. They want to talk to someone, and so give your advocate or your agent for your healthcare, make sure that they have a copy of your advanced healthcare directive. This is not a document you need to keep secret. Make sure your agent has one in their glove compartment. Make sure that part of that health directive has your list of medications. You go into the emergency room, the first thing they're going to want to ask is, what kind of medications is the person on? They're not going to go look through the files. They want to hear it from the person who is with the patient. So is a copy just as good as the original, Steve?
Generally speaking, I think it is, in my experience. We haven't needed an original. We do want to know where the original is, just in case you run into an obstacle where they're insisting upon it. But yeah, copies of most of your estate planning documents, copies generally work just fine. But if we knew we lost the original, I would recommend that we re-execute a new one.
Trevor, do you remember an association name where a consumer can get a hold of the generic geriatric nurses that we use? I can't remember the association.
It's called the Aging Life Care Association.
Aging Life Care Association.
Used to be called the Geriatric Care, but someone got a hold of their marketing department and decided the Aging Life Care. And it's really, I recommend people that a lot of us have parents that don't live nearby, and we're not really familiar with some of the the vetted professionals in their community. That's a wonderful place to start, because it's national, and you just put in a zip code, and it'll give you all different types of care managers in the area that you can contact if, for example, you think that your parents are becoming incapacitated, or or maybe even helping friends out of state or whatever.
Yeah, and they charge somewhere between $100 to $150 an hour, but you're not going to use them 24/7. You're using them to take a look at the medical charts, to take a look at the medications, take a look at what kind of supplements that the person is taking, so that they can give you in layman's terms kind of what is going on. Very, very helpful, and recommend highly.
We're going to talk about them a lot next week. It's Your Money with the medical care planning.
Yes.
on Thursday.
Trevor, say again slowly say what the name is of the organization.
Aging Life Care Association.
Thank you.
DNR, do not resuscitate. The pulse usually is used during approximately a year out, where you are saying, I got about a year left to live. And I see pulse being used in that circumstance. DNR, on the other hand, I see them used as I have 30 days to live, or I'm in my third treatment of cancer. I am 90 years old and somebody pushing on my chest will break a rib. So, just to give you an idea as to when to use these documents.
Well, one thing on the pulse, I like to describe it as it's literally like a prescription from your primary care physician for the first responders. And it also follows you. So if you go to the hospital or into a skilled nursing, it'll still be there next to your bed. So others will, the doctors and staff on site will be able to refer to it.
And let's say you don't have an advanced healthcare directive and medical decisions need to be made. And what happens? Steve?
Again, we're conservatorship again, and this gets into the other type of conservatorship, which is called conservatorship of the person. And so that's a conservatorship for making medical and care type decisions, as opposed to the financial side, conservatorship of the estate. And even though there's two conservatorships, typically if you needed both, you do it at the same time. It would be as part of one legal proceeding. But again, you run into this scenario where if you don't have that healthcare directive, you can run into a situation where the medical provider will not take an instruction. I think in many cases, they will look to the closest family member, spouse, or kids, and will take instructions even without a healthcare directive. But I think at least in today's age, they're looking for that healthcare directive first.
And that's the problem when you have more than one child. Because if you have more than one child, there might be a disagreement between them. And that's when usually, sometimes they have to go to court. By the way, we have approximately about 4 million people here in Orange County, and we have 6 judges in the probate court, and it's packed. So you want to avoid having to go to court. And one of the good things about Steve is that you want an attorney that, especially in the estate planning area, who has the ability to communicate with the family. So hopefully that if there is a problem, your attorney can kind of step in and be a mediator. And I love the fact that attorneys used to be called counselors. And that side of the law, I think, needs to be used a little bit more. But Steve is one of those kinds of attorneys that I think is one of his big qualities. We have about 4 to 5 minutes. Don, why don't you come on screen? Trevor, come on screen. And do we have any questions?
So yes, to interrupt you. It's an interesting question. So if there's an advanced
come on
healthcare
screen.
Oh, sorry, I forgot to turn that on. No, I just like being the voice of God. If there is a pulsed and they have advanced healthcare directive and they do say something different, which one applies? I mean, the answer is you should fix that, but
I'd say the pulse would apply.
Because it's the doctor's order.
Yeah,
I would say the advanced healthcare directive applies.
But the paramedics don't know it.
It depends on the situation. I mean,
Steve, what's the right answer?
Yeah, Steve, you do.
Yeah, wait for me to break the tie. Well, I mean, that's the problem. There's all kinds of, which was signed later. Okay, I think if the pulse was executed after the healthcare directive, I think probably, I always try to look at it as, okay, if a judge was deciding the issue and you had a pulse that was dated later, I think the judge is going to give priority to the pulse form.
Or
over
God,
the
you
advanced
want
healthcare
to
directive.
avoid these situations at all
Yeah,
costs.
but if you're at a hospital and you've got one family member holding up the pulse form and the other one holding up the advanced healthcare directive, what's the hospital going to do? They're going to freeze, right?
Yeah.
They're not going to necessarily going to break that tie or that conflict. They're going to wait for the family to resolve it, which hopefully they can do without having to go to court to kind of decide the issue.
One of the things that I've discovered in working with these various sessions along the way, there's a term that really comes up many times. It depends. And that's not an aging issue that some people might deal with. It depends on the situation. Now, to Trevor's point, like my sister's case, she has it because I'm on her advanced healthcare director. She's in Santa Barbara. If the paramedics come and get her, they can't call me that fast. Therefore, there's a pulse. And no, she doesn't plan to die in a year. But to her, that's what she wants done if the paramedics are there. The advanced healthcare directive can then come into play. In her case, they are the same. So it doesn't matter. But that's a convenience. So,
Any other questions, Don?
Very specific ones that I don't think we really could answer the question for. But no. There was one question, incidentally, that came in on chat, and so I'll be nice and go ahead and ask the question. How does one access the nurse guidance / help?
We just answered that.
Oh, I'm sorry, I wasn't paying attention to you.
Oh, that's okay.
But Pete,
I'll watch the video.
Pete, there's one thing you didn't talk about this session, but I assume we'll talk about it next week in the medical care planning. Is how does even if I mean, I assume a lot of people that serve as agents, even as spouses, but especially if they're not spouses, even really know much what people would prefer. How do they know besides that legal document, like how to get that out of the person that they're going to be helping?
Go ahead, Steve.
Well, I mean, it's about, and this goes with all estate planning documents. There's a certain limitation to, how detailed we can be in there to cover every minute scenario. And so, clients who either have a little letter or memo or that may describe some of these things or have conversations with, their parents or their kids to talk about these things. And Pete, you've often recommended, as Trevor noted, the Your Way booklet is a good way to.
Yeah, it's a conversation starter, and it's I'd like to get a feel for what the person values are, and I usually recommend to individuals not to be a laid out plan, like a building plan of a building and a blueprint that you have to do X here and Y here. Leave it open, because allow your agent to make the best decision for you at the time, and forgive them in advance, because it's a very, very difficult job to make these decisions, and they may do wrong, but they'll hopefully try their best for you. And that's the critical point. And none of us will know exactly where we're going to be when we die. But if it's, we want somebody to make their best effort to help us at the time, if that's what's needed.
So being the host and being the time person that I am, this is Finance and Estate Literacies. This is your estate. This has been week 2, advanced health care, and when you lose your ability to speak, it's very important. Advanced Healthcare Directive and Powers of Attorney. And so therefore I've nominated Trevor to handle It's Your Money next Thursday, because I won't be around. But anyway, I thank you all very much for your time, and it has been a pleasure. And next week we will talk on the estate side in terms of wills and trusts. Thank you very much.
Thank you, Steve.
Thank you, Steve. Thank you, Trevor. Thank you,
for
Pete.
having me.
Thank you, the group. Y'all have a good time. Bye.
Bye-bye.